conducted by the incredible Mark Cobb, a Georgia construction lien law guru. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the fabulous Mark Cobb.
Thank you, Jesse. A couple of things we want to cover today, and we don't have a lot of time, but as Jesse said, my name is Mark Cobb, and I've been practicing law for about 30 years. My focus is on materialman liens and payment bonds. I've done a lot of publishing on the subject, done a lot of speaking on the subject, and the last time that the lien laws were revised, I was one of 3 lawyers to make those changes. Right now, I was talking to a colleague last week, and I think right now we have about $35 million in liens that are outstanding that have come in, since about February or March. So liens are what we do, and I truly would love to have about a 3-day seminar on liens, but unfortunately we don't have that time. So we're just going to dig in and do just kind of some of the things that maybe you're not aware of when it comes to liens. So that way, if you have to file liens, you've got the supporting facts to back that up. One thing I wanted to start with is, change you can make to your contracts. And I realize different companies have different policies. Sometimes you have to go through, your legal department to have a change. And I actually have a full 1-hour seminar I do on things you can do yourself to your contract. But those that have some authority to change the contract or can get that authority, I really think that it's important to make contract changes. That'll be the first topic we talk about. Then we're going to talk about securing your lien rights. Then we're going to address bond rights, which are similar, but yet still different. We like to do that just to confuse people. We'll talk a little bit about the rules and exceptions. Quick discussion on lien law traps to avoid. And then finally, we're going to end with the right way to exchange or release for a check. And as Jesse said, feel free to ask questions throughout, and then for the most part, we'll be answering them at the end of this webinar. So on to contracts. I think it was suggested that I suggest one change to contract, and it's just so hard to limit it to one. But easy things to do with your contract. It could be with terms and conditions if you don't have a formal contract. If you send an invoice and you have that small print down the bottom, I think it's always very important to include a consent to jurisdiction and venue provision. Under Georgia law, typically if somebody needs to file suit, in this case, presumably it would be you as a lien claimant, you file suit where the other party legally resides. So you might be in Fulton County, you might be in Florida, you might be in another country, but you have to file suit in the county where the other party resides. That could be anywhere of Georgia's 159 counties. If you put a jurisdiction venue in there, then you have control over it. And basically what it says is, if there are any collection attempts, any lawsuit coming out of this contract, then they will be held in this county. And I prefer Superior Court of Georgia, but in Fulton County, Superior Court of Georgia, or Chatham County, Superior Court of Georgia. That way, you are in control of where lawsuit is filed. It can be convenient for you, maybe where your home office is or where a significant branch is. It could be where your attorney is located. But that way, you have the say and the potential to lower your collection costs. Because it's one thing if your offices are in Cobb County and you sue somebody in Marietta. It's another thing if your offices are in Cobb County and you sue somebody down in Lowndes County, down where Valdosta is. So that's an important provision to include. Also, and it's amazing how many times we don't see this, do include a provision for prejudgment interest. Be very clear. I mean, if you have a credit card, you can look at the bottom of your statement and essentially copy that statement. But the payment is due net 10, net 30, whatever your payment terms are. After that, interest will accrue at 1 to 1.5% per annum, per month, per annum, 18% per annum, and that just helps you. It is likely or increases the odds that you'll actually get interest, which is additional revenue for your company. It's also great negotiating tactics. I mean, frequently, if you are negotiating payment, that may be the first thing out the window, but that still leaves your principal balance as the second negotiation attempt. So it can help in many ways. Similarly, in Georgia, if you want to enforce attorney's fees, you really do need to include that in your provision, and having that cost in there can also help not only recoup your cost, but it can also help again with the negotiation. Now, sort of the meat of this is how we protect our lien rights, and so there are so many things. I could probably do a 1-hour seminar just on this one topic, but I chose just two of the more significant things that we see come up a lot. The first of all is Georgia's statutory notice scheme, and the good folks at SunRay are very knowledgeable about this, and they're very helpful. But it is so important. If you are required to provide notice in order to preserve your lien rights, and you fail to provide that notice, then you do not have lien rights. And so we're going to look at that just a little bit deeper. Georgia's statutory notice scheme is voluntary. What that means is the owner of the project or the general contractor of the project can say, hey, we want to implement the statutory notice scheme. They implement it by filing a document called a notice of commencement. That's filed in the legal record at the Superior Court in the county where the project is located. And that notice of commencement, when it's valid, when it's correct, gives you, as a subcontractor or supplier, very pertinent information about the project. It should tell you the name and address of the true owner of the project. That's very useful when it comes to filing a lien. It gives you the location of the project. For private projects, it should give you the legal description for the project. It will let you know if there's a construction lender on the project. It will also give you the name of a surety if there's a payment bond on the project. So it has very good, useful information. So if that is filed, what does that mean to you? Well, to certain people, to a certain class, you must give a notice to owner and a notice to contractor. So it's 2 letters, 1 letter going to the owner, 1 letter going to the contractor, the identical letters, often called notice to owner, NTO. Other states sometimes call them notice of furnishing. But you must send that to the owner and the contractor within 30 days of starting the work. So if somebody comes in and says, hey, I'm buying, lumber, I want the delivery on, 10 days from now, I would go ahead and get that notice out, because you have 30 days from the date of that first delivery to get the notice out. The notice has to be technical and has to meet the statute. And so, for example, the NTO is supposed to go to the owner at the address as stated in the notice of commencement. That's one example. You also have to do the same thing to the contractor. So you have to have a copy of the notice of commencement in hand, usually, in order to do a valid notice to owner, notice to contractor. Similarly, you have to identify the project as described in the notice of commencement. Ultimately, when you look at it, this is to make it clear for everybody, so that someone who provides the notice to the owner can look at it and say, oh, this is our project in Albany, Georgia. Oh, I see the subcontractor or the sub-subcontractor is doing some of the electrical work or providing materials. It gives the owner the ability to track payments downstream. If an owner or general contractor implements the statutory notice scheme by filing the notice of commencement, then it applies to those working on the project who do not have privative contract. That's, I think, the only legal term we're going to have to deal with here, but privative contract means you're a party to the contract. And so if you look at the typical scheme, an owner has a contract with a general contractor. A general contractor has a contract with a subcontractor. Subcontractors have contract with sub-subs and also with suppliers. So when you look at the purpose of that statutory scheme, it's so the owner can track money downstream. The owner knows who the GC is. They have a contract with the GC. The general contractor is the agent for the owner. The general contractor knows every sub that's on the job. They have a contract or they're aware of every single subcontractor working. If the contractor is self-helping, they know who they're getting the supplies from. So there's no reason for that notice. The contractor already knows you're on the job. But they don't know who the subcontractors are, and they don't know who the suppliers are to subcontractors. And so by providing this notice, it preserves your lien rights. Again, you must do it within the first 30 days of starting work. If you fail to do it and there's a valid notice of commencement, you probably don't have lien rights. Another way that people preserve their lien rights is by filing something called a preliminary lien. Some states file preliminary liens regularly. In Georgia, they're on the rarer side, and it's a preliminary lien. It's a document that anybody can file. A general contractor, a subcontractor, a sub, or a supplier can file, and they file it in the courthouse in the county where the project is located within the first 30 days of starting work. Same deadline as getting out the notice to owner or notice to contractor. And that preliminary lien is not a lien. It's sort of viewed as a pseudo lien. And so what it tells the owner is there are certain defenses an owner might have that could defeat a lien. There are certain defenses a general contractor might have for defeating a lien, and a preliminary lien can thwart those. And so you say, well, why would I want to file one? We tend to recommend them two situations. When for whatever reason you're supplying or providing subcontractor work to someone with a high credit risk. In theory, you shouldn't give credit to anybody who has a high credit risk, but there are political situations, there are old customer relationships, those things, and if there's a high credit risk, I would suggest filing a preliminary lien, and also value. I mean, truthfully, I've got a couple of clients who file preliminary liens regularly, but they are lumber companies who are supplying over $1 million of lumber on multifamily housing. And so you tend to look at large dollar amounts. Would I file one for $50,000? Rarely would I recommend that. So, but it is something you need to be aware of. It is something that you could utilize in the situation of high credit risk or a large value. Then moving on to bond rights, it's very similar. So under bond rights, if it's a private payment bond or a state of Georgia payment bond claim, often known as the Little Miller Act or the Georgia Miller Act, you have the same obligations to give a notice to owner or notice to contractor if the GC or the owner has instituted the statutory notice scheme. And it applies to the same class of providers. So if you're a general contractor, you do not need to give the statutory notice scheme. If you are a subcontractor working directly for the prime contractor, you do not, none of this applies to you. But if you are a subcontractor, if you are a supplier to subcontractor, then you must provide notice to owner, notice to contractor within 30 days of starting work. Same obligations. It's important to know that payment bonds, at least under the Miller Act, which is federal law, or the Little Miller Act, which is Georgia law, it's basically a substitution for a lien. So you do see a lot of similarities here. The notice scheme is identical. One important thing to notice is that although the statutory notice scheme must be complied with on all Georgia projects, so that's state of Georgia, that's municipalities within the state of Georgia, Georgia state agencies, you do not have to do this on federal projects. Federal projects, is a different beast. The Miller Act is different, and so this Georgia statutory scheme does not apply and is not required to be given. So it's important, when you look at liens, it's important to sort of realize the history. And so liens are a very rare creature legally. The United States is the only country in the world that provides liens, construction liens, materials liens, mechanics liens. It's very unusual because generally if somebody has a contract with another entity, subcontractor with the prime contractor, Their only remedy is against the person with whom they contracted. But lien law says, hey, even though you have that claim from a subcontractor to a contractor, if you comply with all the statutory requirements, then you may also be able to go against the real estate where your work was performed, or your materials, they were incorporated into the business. Your materials were incorporated into the project. So I kind of describe it loosely as a post personal guarantee for contractors. It's a big win for contractors and suppliers. And until you actually see it in action, it's hard to believe how important it is and just what an amazing gift it is. The reason for this, and it's important to have a little bit of history here, is traditionally, and I'm going back 1,000 years now, landowners were called landed gentry. And they're considered to be rich. They're considered to be smart. And again, 1,000 years ago, the laborers were considered to be uneducated and poor. And they had very little rights if they performed the work, if they built a stone wall, if they were to dig a moat. They had little, if they weren't paid, they had really no recourse. And so the concept of a lien came into place saying, hey, the landowner, the land gentry, benefited from this wall, benefited from this moat. Therefore, even though the stonemason did not have a contract with the landed gentry, they're still responsible for the payment. So this is a big deal, but everything has to be done right. And we see the code section is 44.14.361.1 in the official code of Georgia. And every element of a lien has to essentially be perfect. But where we see problems, there's three areas where we see problems. The first one is the deadline. The deadline is 90 days from the last day worked. Sometimes it's a very clear date. If you deliver materials and they were delivered on day A, you can calculate, you can count 90 days, you know the last day that you worked. For other specialty contractors, it may be a little different. Maybe there's work that was done. Maybe you're called back on the project to finish something, do punch list work. There may be warranty work. Maybe the scope has extended. They've added something last minute. Hey, since you're here, will you also do this? But you must be within 90 days. If not, the lien is invalid. And so I always encourage clients, file early. Do not wait to the 89th day. Do not wait to the 80th day. Do it around day 45. Some clients of ours do it within the first week, and I think that's even better. But do not let that lapse. You have to be careful. Typos can invalidate a lien. Just a simple typo may not. If you say A instead of AN, and that wouldn't. But a typo, there's a certain statutory requirements that must be on the lien, and there's an example that's the lien must say that it expires 395 days from the date of filing, unless blah blah blah. There was a case where somebody accidentally typed in 365 days. That was construed to invalidate the lien. Similarly, with the amount needs to be accurate. You can't guess. You have to have the accurate amount. It's on your burden as a lien claimant to be able to show the amounts and be able to show that they were incorporated into the project. And one big thing I want to remind you of, and we'll talk about this a little bit at the very end, but watch out for signed, unpaid Georgia lien waivers. If you have signed a lien waiver, but you have not received payment, please get those to whoever's filing your liens, your SunRay, attorney, whoever it is, because it's important that they invalidate those lien waivers prior to filing the lien. Couple of things just to avoid. Again, we've already mentioned a little bit, but make your claim as early as possible. Do not wait. I was brought in a consultant on a case just yesterday, significant, six-figure lien, and there's a debate as to whether it was filed 1 day later, 2 days later. Was it valid? If the person filing the lien had just done it a week earlier, there'd be no question at all. So sadly, the sad reality is the lien claim is now spending thousands of dollars to defend something that could have been easily defensible had it been filed a week earlier. They're not questioning the technical issue of the lien other than the date. This is important too. Separate projects. So sometimes clients will call and say, hey, I'm building 5 houses. I need 5 liens. Okay, well, what are the lien amounts? Well, I'm owed $150,000, so I guess $30,000 per house. That does not work that way. You have to, from the very start, keep separate projects. You have to know that house 1, house 2, house 3, house 4 are different. You may spend different amounts. There may be different stages. Perhaps house 1 has been finished. House 2 and 3 are 80% done. House 4 is 90% done. House 5 has just been started. So you cannot divide those. It is on you to have the proper accounting. And similar to what I alluded to earlier, please document your last day worked. I'd rather have a photograph than nothing. But an email, a letter, something saying, hey, we came back out to do the punch list items today. I wanted to let you know that we finished the, doing, number 1, number 2, number 3, number 4. If you have any more problems, let me know. That is just wonderful and can save you money just defending a lien when it doesn't need to be defended. And so I want to talk just a little bit as we close about how to exchange a release for a check. And that's a popular question that we get. So, and this gets into a very technical aspect of lien waivers in Georgia. Georgia only has 2 lien waivers that are enforceable. So I see a lot of time contractors come in from another state, they ask subs to sign that state's lien waiver or their own lien waiver. That's fine. They are not valid. Now, there may be other problems. Maybe it's an affidavit form. Maybe it's some testimony that can be used against you. But from a lien enforcement mechanism, they're not valid. You still have lien rights. So in order to, the only forms you can use in Georgia are the Georgia statutory forms. And they're identical except for, as you can guess, one is for interim payments. And then there's a slightly different form for the final payment. If you use that form, then the form is conditioned upon payment for 90 days. So if you've sign a lien waiver January 1st, then you have until roughly the end of March to get payment. If you don't have payment by that time, then that lien waiver will automatically transform into an unconditional lien waiver. So after March 31st, April 1st, you cannot file a lien for the amount of that lien waiver. You still have contract rights, you still have some other rights to payment, but not through the lien vehicle. So what you do in that interim, if you don't get paid, is you have to file an affidavit of non-payment. And that's a document that's filed at the courthouse and says, hey, I signed a lien waiver January 1st. It's May 13th. It's March 13th. I haven't gotten paid, and this hereby voids the lien waiver. Therefore, I can still file a lien for that amount if I want to. So if you're getting a check, I would only sign the Georgia statutory form, and I would calendar it to make sure that that check or that wire or whatever the payment is goes through. And if there's any payment issue whatsoever, if they say, oh, I'm so sorry, the bank had a problem, let me write you another check, I would go ahead and invalidate that Georgia statutory form by filing an affidavit of non-payment. But if you go and you pick up a check and you sign the affidavit, you sign the lien waiver on that day, then you do have that 89-day period essentially to void it. And so that takes care of most of the time for picking up a check. If there's a larger issue, I certainly do encourage joint checks. I think that's a wonderful thing coming from an owner or from a prime contractor. They're less likely to cancel payment or frankly not have enough money in their account. And then there's always another option too, and we see this a lot with liens, is where the money is placed in an escrow account so that the escrow, there's time to make sure that the wire comes through or the check is good, and then the lien is released, and then the money is dispersed to the third parties. It takes a little bit longer. Arguably it probably takes about 10 days or maybe a little bit longer. Has a little bit of cost associated with the escrow account, but that is certainly what we recommend, and particularly in high amounts if there's an issue. and contractors and owners are generally, amenable to this. That has concluded the very brief but hopefully informative information, and I'm available for any questions for anybody.
Well, first of all, Mark, you are incredible as always. There are a couple of questions that have come in. Pardon me. I will start with the first one. It says, is a written contract required to file a mechanics lien in Georgia?
It is not, but that reminds me of something else that I should put on this list for next time. If your trade requires a license, you must be a licensed contractor in Georgia. And I mean, if you're so, for example, in Georgia, painters are not required to be licensed. If you don't have a contract, you're not licensed in Georgia. A painter can still file a lien. But if you're an electrician and a licensure is required, you must have a Georgia license in order to file a lien.
Perfect. Thank you for that clarification. Another question came through. It says, how do we get a copy of that notice of commencement?
So it's public record. So you can always go to the courthouse and look for it. There are online services that provide it. I have an annual subscription to the Georgia Superior Court Clerks Authority, I believe is the name, and I have access to it. You have to know what names to index, and you have to figure out like legally how they're indexed. But it is possible, and because it's public record, I know you get the courthouse, and I think there are other online services that probably do it relatively cost effectively.
Yep. And also you can simply ask your contractor for a copy of it. They should be able to provide it to you as well. All right. And then another question that has come through, it says, by Georgia statute, is it, and I believe you've already covered this, so I apologize, but by Georgia statute, is it required to send a notice to contractor if there is a notice of commencement, or is this just a recommendation?
You have to, if you're a subcontractor or a supplier to contractor, in order to preserve your lien rights. Now, if the dollar amounts don't justify it, you may not care about having lien rights. So there's reasons why you might not, but yes, you should.
Okay, perfect, beautiful. All right, another question that has come through. It says, in Georgia, are property owners able to file a lien prohibition within their lien provision that prevents a lien from being placed on their property? And if so, do you then have the ability to file the lien against just the tenant's interests instead of the real property?
So I've never heard the phrase that began that question. I apologize, I can't see it. So that must be coming from some other state. But no,
yeah,
Georgia.
This is a common thing that happens in Florida. We see it as well. Gotcha. So I know what they're referring to.
Cool. So no, the only way to waive a lien is using the Georgia lien waivers. You cannot waive it in a contract. You cannot waive it at all. I will say this: if you are doing work or supplying materials to a tenant, you may only be able to have a lien against the tenancy and not the owner. Just depends upon the circumstances.
Got it. Okay, perfect. And then another question that came through is, can you amend a lien after it's been recorded if you are still within the deadline, just to correct information or update the amounts or whatnot?
As long as you're still within 90 days, yes, you can. And that's another great reason why you want to file a lien as soon as possible. Also, just as an addendum to that, you can also file, even after the deadline, you can reduce the lien amount. So what sometimes happens is you get partial payments and the payer wants to insist the lien amount gets reduced. You can do that and the original lien still stays in place. You cannot increase it, but you can decrease the value of the lien.
Beautiful. Well, thank you so much for answering those questions. I do think that that's all the questions that have come in so far. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to help answer any questions we can. Can you go to the next slide for us, please? All right, beautiful. Please, here are some of the SunRay's resources to help you stay organized, know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. As we kind of touched upon, every state is a little bit unique and different with their lien laws, deadlines, restrictions, document names, all of that. So please, if you're working in a neighboring state, check that out so that way you know what the expectations are and what you need to do to ensure that you have protected yourself and that your lien will be perfect and not able to be contested. All right, and then the next slide for me, please. All right. If you don't mind, give us a quick moment just to review us on Google. We'd really appreciate it. It only takes about a minute of your time, but it helps other contractors like yourself and suppliers hear about us, and it also provides that feedback to us. That way we can always better ourselves. And then the next slide, if you don't mind. All right, so that is all we have for you guys today. Thank you again for everybody that was able to attend. We hope to see you at our next webinar. Mark, I really can't thank you enough. Thank you so much to everybody. I hope everybody has a beautiful and wonderful sunny day. Thanks again, everyone. Thanks again, Mark.